Hi all, this is Uma Bharathi. I am a company secretary and I have almost 4 years of experience in teaching, and I'm currently also working with a private company. And so let us start with a paper 2 foundation course, that's the business laws. So in this paper you will learn about the regulatory framework, you will also learn about the negotiable instrument, you'll learn about the LLP Act, you will also learn about the Partnership Act, and you will learn about the Companies Act. So you will learn almost about all the laws which is related to the creation of a company, creation of establishing, how can you establish a company, how can you start a limited liability partnership, how can you start a partnership act. So all of those things we can study in this paper. So let us start with the first chapter, which is the regulatory framework. So let us learn what is a regulatory framework. So first of all, to know what exactly the regulatory framework. So most of you all will be aware about the, say for example, the share market which is being regulated by SEBI laws. SEBI regulates the share market, and the bank is regulated by RBI. So RBI, Reserve Bank of India, is the regulatory body for all the banks, and we have for insurance we have IRDA. Then we have IBBI for Insolvency and Bankruptcy Board. So let us learn about each regulatory framework in the first chapter, and we will also learn about what is law and why we'll have to implement the law, and what are the sources of law. We'll also learn about what are the sources of law. So first, coming to what is law. So in the first chapter, let us see what are the objectives and what are the contents in the chapter. So in the first chapter, it's just a brief introduction. As you all know that this paper is full of theory, so you don't have to get scared about the theory paper. I'll make you all to mark the important points, so you can just have the look to the important points. So in the first chapter we have an overview chart which says what are we going to learn in this first chapter. We learn about what is law, what is enforcement of law. Then in what is law, will also learn what are the sources of law. So the main source of law is the constitution. So what is the sources of law, then process of making a law, how does something become a law. So what is the process of making the law, then what are the types of law. So we have various types of laws. Say for example, we have criminal law, civil law, common law, principles of natural justice. So when we come to the other part of the chapter, we have the major regulatory bodies. So what are the major regulatory bodies? We have Ministry of Finance, then we have Ministry of Corporate Affairs. MCA is Ministry of Corporate Affairs. SEBI, which is Securities Exchange Board of India, which regulates the share market. We have RBI, which is the Reserve Bank of India, which regulates the banks. Then we have IBBI, which is the Insolvency Bankruptcy Board of India. And we also have Ministry of Justice and Ministry of Law and Justice. So now let us first part you can just skip, that's an introduction to the entire course. Entire subject, you can just skip the first part. So coming to the second part, what is law? So what is law? Law is nothing but it is a duty, it is an obligation on any person in the country to implement. So for giving a very simple example, so whenever a person is on the road, so he has to implement the traffic rules. And what if there are no traffic rules? What if there were no traffic rules at all? So what happens if there are no traffic rules? Person does not wear helmet, person does not have license, person does not can go anywhere on the road, does not follow the rules at all. If it is one way, even though if it is one way, the people go take the two-way roads. and which leads to accidents, which leads to death, life threats. So it becomes difficult for a person to go on the roads if there are no traffic rules. Say for example, in certain areas there are no traffic signals, which is a very small areas, there are no traffic signals. So what happens in such kind of routes, so all from people from all the four ways they come and they get clashed, because no, everybody wants to go fast, everybody wants to go first, so nobody will leave the way to the other person. But what if there are signals? Say for example, we have four ways, and what if there are signals? So if one way has a green signal and the other three ways has red signal, so the people standing in the opposite side will first, people standing with the green signal will move first, and for the other three they will be a red signal. So that means that it is so organized way that people can easily move around from one direction to the other direction. So that is where if we follow these kind of traffic rules, the life becomes easy on the roads. So that is one of the rules that we have to follow. And other laws, say so this is a simple example that I gave you, and so such kind of laws are very important for the companies, very important for a common human being, very important for all the companies to implement such kind of law. What happens if there is no law for a company? So if there is no law for a company, just like people get messed up on the roads, people also get messed up in the company. There's no audit that will take place. People can do whatever they want with the money. People can work however they want. They use the sources of the company however they want. So there's no proper direction for the company. They don't file annual filings, they don't do annual returns, nothing. Then it becomes very difficult. So that is where law is very, very important. Now let's learn what is a law. Law is a set of obligations and duties imposed by the government for securing welfare and providing justice to the society. India's legal framework reflects the social, political, economic and cultural aspects of a vast and diversified country. You must be aware that India is a parliamentary democracy. We have a constitution which is the basis and sources of all laws. Please mark this line. We have a constitution which is the basis and sources of all laws, as I told you before. So constitution is the main source of creating the laws for all the laws. So what happens is that we have two kinds of legislature. One is the parliamentary, which is wherein the central makes the laws, and we have the state assemblies where the state makes the laws. So we have country, we have laws for the whole country, we have laws for the state as well. So the laws for the country is made in the parliament, the laws for the state is made in the state assemblies. So let's see. We elect our representatives to the parliament as well as to the state legislatives of various states. These representatives of the people make laws in the parliament or their state assemblies, as the case may be. So the country laws are made in the parliament, the state laws are made in the state assemblies. So you can mark that line. We elect our representatives to the parliament as well as to the legislative assemblies of various states. These representatives of people make laws in the parliament. So the representatives, as in the MPs, from various states become the representatives of the people in the parliament. So they make the laws in the parliament for the whole country, and the state assemblies makes the state laws for that particular state. So for example, Karnataka has a different state laws, Madhya Pradesh has different state laws, Maharashtra has different state laws. So those state laws are made in the state assemblies by their respective state governments. Okay, as the case may be. So parliament is the ultimate law making body. Please mark that line. Parliament is the ultimate law making body. Okay, so the law passed by the parliament may apply throughout all or the portion of India, whereas the laws passed by the state legislation apply only within the borders of the state concerned. as I told you before also, like parliament, the laws which is made in the parliament, the laws which are made in the parliament are for the whole country, but the laws which are made in the state is for that particular state itself. So we learned two things. No, we learned three things. First is constitution is the sources of all laws, then parliament makes the country laws, then the state assembly makes the state laws. Okay, let's continue. The Government of India Act 1935, passed by the Parliament of the United Kingdom, is the precursor for the Constitution of India. It defined the characteristics of the government from unitary to federal. Now, what is the characteristics from unitary to federal? So, let us take a small example in this. So, you have, say, imagine you have a company and you are the boss of your company, and initially you had only say 10 people, so you were able to manage the company. So say tomorrow you have grown big and you have like 2000 employees with you, and you are not able, and you have no, you don't have so much of time to take the decisions on a day-to-day basis. So what do? So you decentralize your decision making. Centralize your decision making is nothing but you take the decision for the whole company. Decentralization of decentralization of decisions is nothing but you allocate the decision powers to the particular department, say to the finance department, say to the marketing department, sales department. So you decentralize your powers to the different variety or different departments. So that is decentralization of decision making power. So your powers are given to the different departments. So they take the department heads take the decision for the companies. So what is federal? So federal, from unitary to federal. So unitary is nothing but one, right? So now federal is nothing but dividing the powers. So powers are distributed among the center and the state. So not every decision can be taken by central. So what does a central do? Central has divided the powers to the state. So now the state also has the power, the central also has the power, but the ultimate power is with the center itself. Okay, so now we have learned two words, unitary and federal. So unitary is one wherein you don't have the distribution of powers does not exist, but in federal we have the distribution of powers. Let's continue to read. Powers were distributed between the center and the state to avoid any disputes. So the powers between the center and state has been distributed. So in order, see, for as I told you, like a very simple example, in the company not every decision can be made by a CEO or made by the head of the company. So on a day-to-day basis it becomes very difficult for the decisions to be made by the head of the company. So that's why they they have distributed the powers to the variety to different departments, so that it becomes easy for the departmental head to take the decisions on a day-to-day basis. Just like that, we have the center and the state divided powers. Okay, in 1937 federal court was established. Please mark this line. In 1937 federal court was established and had the jurisdiction of appellant, original and advisory. The powers of appellant jurisdiction extended to civil and criminal cases, whereas the advisory jurisdiction was extended to the powers to the federal court to advise Governor General in matters of public opinion. So we have two things here. So federal court was established and had a jurisdiction of appellant and original and advisory. The powers of appellant jurisdiction extended to civil and criminal cases. So there are there are two laws. One is civil law and criminal law, which any cases with respect to the civil and the criminal law, the appellant jurisdiction had the power to take the decisions. Okay, whereas the advisory jurisdiction was extended to the powers to federal court to advise the Governor General in the matters of public opinion. So we have two courts. One is the federal court and one is the advisory jurisdiction. So say for example, I'll just tell you. Okay, so we have federal court and we have advisory. Just a minute. Okay, so we have okay, so we have a federal court. Okay, say we have federal court and we have advisory jurisdiction. So the federal court takes care of civil cases and it also takes care of criminal cases. So this advisory jurisdiction will, what does this one do is that it will extend the power to the federal court in order to advise the governor general in the matters of public opinion. So this advisory jurisdiction will only help the federal court to advise the governor general to take the decisions on public opinion. So this is the advisory jurisdiction only gives the advisors to take the decisions on public opinions. So this does not take any decisions for criminal or civil cases. So there are two things, one is the federal court, one is the advisory jurisdiction. Okay. So the federal court was established and had a jurisdiction of appellant. Okay, just before that line, mark that line. Powers were distributed between the center and the state to avoid any disputes, and then you can also mark in 1937 the federal court was established and had the jurisdiction of appellant and original and advisory. The powers of the appellant jurisdiction extended to civil and criminal cases, whereas the advisory jurisdiction was extended to the powers to federal court to advise the governor general in the matters of public opinion. So you can mark that one as well. Okay, so opinion. Then let's continue. The federal court operated for 12 years and heard roughly 151 cases. The federal court was supplanted by India's current apex court, the Supreme Court of India. Please mark this line. What happened to the federal court? The federal court operated for 12 years. So federal court was operated for 12 years and the federal court also gave the decision for 151 cases. So the current Supreme Court was the federal court before. Continue reading. The federal court was supplanted by India's current apex court, the Supreme Court of India. Please mark this line. The federal court operated 12 years. The federal court operated for 12 years. After the establishment of federal court, it operated for 12 years and it also took the decisions for 151 cases. And then the current Supreme Court was replaced. The apex court, the federal court was replaced by the current apex court, that is the Supreme Court of India. So now currently it is called as Supreme Court of India and not the federal court. Okay, let's continue. The Constitution of India 1950 is the foremost law that deals with the framework within which our democratic system works. The Constitution of India 1950 is the foremost law that deals with the framework within which our democratic system works. So, As I told you before also, our constitution is the main source of our law. So that our constitution gives all the laws for the country to work. So it also just read this line, it says that the law that deals with the framework within which our democratic system works. So I'll give you an example here. Just like our companies have a memorandum and articles of association, so within which the company has to operate within the memorandum and the articles of association. The company cannot go beyond the memorandum and the articles of association. So just like that, we have the constitution within which the country has to operate. The country cannot or beyond go the constitution. So all the sources of law is from the constitution, and therefore the company cannot go beyond our constitution. Just like the articles, just like your memorandum and the memorandum of association and articles of association of a company, beyond which a company cannot act. So just like that is our constitution for our country. Okay. Deals with the framework within which our democratic system works, and our laws are made for the people, by the people. Laws are made for the people, by the people. Okay, who makes the law? Law is made by the parliament, and it is made in the parliament and state assemblies. And who are the people, and who is operated in the parliament? People are operated, the representatives, the parliament people are operating. They come together, they take a decision on a particular subject, they take a decision on particular subject even in the state assemblies, and they make a law. Who is making the law? For the people. For whom it is making, parliament is making the law? For the people. And who are making the laws? By the people. People are making the law, people are for the people, for the law is made for the people. Okay. The constitution also provides for and protects certain fundamental rights of citizens. Okay. The constitution also provides for and protects certain fundamental rights of citizens. There are fundamental rights of I think everybody are aware about these fundamental rights. So these fundamental rights are rights for every citizen of the country, wherein they can have the right to education, right to speak. There are certain fundamentals that everybody are aware of. So these fundamental rights cannot be taken away by anybody in the country. So this constitution provides for the fundamental rights for every citizen of the country. It also lays down fundamental duties as well as the powers and the duties of the government, both in the center and the state. Just like we have the fundamental rights, we also have the fundamental duties to be given to the government, to be implemented by every citizen of India. Just like we have fundamental rights for every citizen of India, we also have fundamental duties to be undertaken by every citizen of India. So where there are rights, we also have the duties to be conducted, as well as the powers and the duties of the government, both in the central and the state. The laws in India are interconnected with each other, forming a hybrid legal system. Okay. The people who wrote the constitution decided to divide the law-making power between the central government and the various state government. So the Indian constitution has 3 lists: central list, state list, and joint list. So as I told you before, that we have we have 2 governments, central government and the state government. So the center makes the laws in the parliament, the state makes the laws in the state assemblies. So now the constitution has divided the law making power to the central and to the state. So we have 3 lists, that is central list, state list, and the joint list. Central list, we take the decision for the whole country. In the state list, we take the decision for that particular respective states, and the joint list is for both central and the state. Okay. Now depending on the list in which it figures, matters would become the subject for the central law and the state law. For example, income tax is a central subject. So throughout India, we have only one law for income tax, which is implemented by the central government through the Ministry of Finance. We also have matters for which both central as well as state governments can pass laws. Levy of stamp duty is such an example. Both central government and state government have law governing levy of stamp duty. Okay. Now let me just make you understand these, what are these state laws, central list, state list and joint list. So central list, so in the central list, the central government has the power to make the laws. In the state list, the state government has the power to make the laws. Say for example, income tax is under the central list. So the whole India has one income tax law which comes through the Ministry of Finance. So joint list is nothing but, say we have something called a stamp duty. Stamp duty is made both by the central and by the state. So state can implement their own stamp duties, or if they don't want to implement the state stamp duty, they can also implement the central stamp duty. Okay, now let us know the process of making a law. Now let us understand what is the process of making a law. So when people come in the parliament to make the law, or in the state assemblies to make the law, so what are the process, how do something become a law? So let us discuss how it happens. When a law is proposed in the parliament, it is called a bill. After discussion and debate, the law is passed in Lok Sabha. So what happens is that in a say for example, if there is any particular subject that they want to implement, right, they want to make something as a law. So first, with all the discussions, with everything, they come up saying that this has to become a law. So what happens is that before they consider something to be a law, it is called as a bill. So when a law is proposed in the parliament, so people come together in the parliament to make a law. So what happens is that that particular matter which the parliament wants to make it as a law, that is called as bill. After discussion, so the people in the parliament, after they discuss and they debate, so they are opposition parties, right? So if the ruling party says that this has to become a law, then the opposition party will also give its own opinion why it should not become a law, right? So after after discussions and debates, and after a certain period of time, it will take a lot of time bill to be passed in the parliament. So after all the discussions and the debates, the law is passed in the Lok Sabha. So there are two houses, Lok Sabha and the Rajya Sabha. So first the law is proposed in the parliament, then that particular law, before stating it to be a law, then it is called as a bill. Then after discussions and debates, it is passed in the Lok Sabha. Thereafter it has to be passed to the Rajya Sabha. Once the Lok Sabha has signed, then it will be passed to the Rajya Sabha. It then has to obtain the assent of the President of India. Now understand this concept. So before passing some matter as a law, it is called as bill. So once the bill is after the discussions and debates, once the bill is passed by the Lok Sabha, it will then be passed by the Rajya Sabha. When both the houses, that is Lok Sabha and Rajya Sabha, has approved it, then it has to obtain the assent. Assent is nothing but take the opinion and the approval from the President of India. Once the President of India signs it, then it becomes the law. Understood? Finally, the law will be notified by the government in the publication called the Official Gazette of India. The law will become applicable from the date mentioned in the notification has effective date. Once it is notified and effective, it is called an Act of Parliament. Okay, mark this line. The law will become applicable from the don't mark everything, mark only the last line. Once it is notified and effective, it is called as the Act of Parliament. So once President gives the assent to that particular matter of law, then once it has been once the President of India gives his or her assent, then it is finally published in the official Gazette of India. And once it is published in the official Gazette of India, it should also mention from when it is effective. Say for example, now you are publishing something on some website, but from when it is effective. So if the law is published on the official Gazette today, but you should also mention from when it is effective from April 1st, effective from Jan 1st, effective from December 31st. So you will have to mention when it is effective. So from that particular day, the law comes into the picture. Okay. Now let us also study what are the types of laws in the Indian legal system. Okay, now let us understand what are the types of laws. So as I told you before, like we have criminal law, civil law, common law, principles of natural justice. What are criminal laws? Criminal law is concerned with the laws pertaining to the violations of the rule of a law or public wrongs and punishments of the same. Criminal law is governed by the Indian Penal Code 1860, the Code of Criminal Procedure CRPC 1973. The Indian Penal Code 1860 defines the crime, its nature, punishments, whereas the Criminal Procedure Code 1973 defines exhaustive procedure for executing the punishments of the crimes. So we have variety, like there are a lot of criminal that takes place on a day-to-day basis. So this criminal law is a law which gives directions only to certain particular incidents that has occurred, which is criminal in nature, which can be a murder, which can be a rape, theft, which can be some cheating, some fraud, which are all criminal laws. Civil laws are different from your criminal laws. So criminal law is governed by the Penal Code of 1860. It is governed by the Code of Criminal Procedure 1973. So just mark this line. The Indian Penal Code 1860 defines the crime, with its nature and punishment. The Indian Penal Code defines definition, and the CRPC definition are different for criminal. What exactly they define as a criminal. So the Indian Penal Code defines the criminal by its nature and the punishment, whereas the Criminal Procedure Code defines through exhaustive procedure for executing the punishments of the crime. What can be a criminal? What are the crimes? For example, murder, rape, theft, fraud, cheating, and assault, or some of the examples of criminal offences under the law. Now, what is civil law? So the matters of disputes between the individuals or the organizations are dealt with under civil law. Civil courts enforce the violation of certain rights and obligations through the institution of civil suit. Civil law primarily focuses on dispute resolutions rather than punishment. Now, what is a basic difference between a criminal law and civil law is that criminal law is exhaustive. It is extensive to the death of some person, or extensive to threatening the life of some person, or where are some instruments used and all of those things. But civil law is not like that. Civil law is just a verbal, like acquisitions on some person, or violating some individual's property or something like that, and which is an conflict between the two individuals, or there can be a conflict between the organizations wherein they don't create any death threat to some person. If there is any death threat, or if there is any exhaustive allegations on the other person, then that becomes a criminal cases. But when it comes to civil cases, it is not of the death threat, but it is of disputes between the individuals and the organizations, which comes under the civil law. Civil law primarily focuses on dispute resolution rather than the punishment. So you can mark this line. Civil law primarily focuses on the dispute resolution rather than the punishment. The act of process and the administration of civil law are governed by the Code of Civil Procedure 1908. CPC. Civil law can further be classified into law of contract, family law, property law, and the law of tort. So in under civil procedure, so the civil law has different again the civil law is divided into, further classified into law of contract, family law, property law, and law of tort. So as I told you before, like in criminal laws there are no subdivisions. So any criminal that has any cases of death threats or any life threatening event that has occurred, which is all a criminal law. But under civil law, which can be a family issue or it can be a property issue, that all comes under civil laws. Some examples of civil offences are breach of contract, non-delivery of goods, non-payment of dues to the lender or seller, defamation, breach of contract, and disputes between the landlord and the tenant. So there can be sometimes, say you are in employment with some company and you breach the contract, that means you break the contract. Say the company has a contract with you for 2 years but you work only for 1 year and you are breaching the contract, that's a civil case. So then that's a breach of contract. Then non-delivery of the goods, so you are a business person and you say that you deliver the goods within the set period but you don't deliver the goods, that's a civil case. Then again a non-payment of dues to the lender or the seller, defamation. So you have purchased some goods from seller and you don't make the payment, that's a civil case. The seller defamation, then what is the defamation? So you don't the name of that person has been defamed, so you don't respect that person or you defame that person, then it's a seller defamation. Breach of contract, again the same, and disputes between the landlord and tenant. So all of these cases come under civil law. Now let's go to common law. A judicial precedent or a case law is a common law. A judgment delivered by the Supreme Court will be binding upon the courts within the territory of India under the Article 141 of the Indian Constitution. So just you can mark this line. The judgment delivered by the Supreme Court will be binding upon the courts within the territory of India under the Article 141 of the Indian Constitution. So say for example there are different courts as well. So just like we have different laws, we also have different courts. So say the highest court of India is the Supreme Court. So any court decision, either the judicial court or the high court or any court has taken certain decision on something, and if a person wants to go to the Supreme Court and take the decision, so any decisions that is taken by the Supreme Court will be the final decision. There is no any other court above the Supreme Court. So above the High Court there is a Supreme Court, but above the Supreme Court there is no any other court, so you cannot go to any other court other than Supreme Court. So the decisions taken by the Supreme Court will be the final one. Then the doctrine of stare decisis is the principle supporting common law. It is a Latin phrase that means to stand by that which is decided. So the Supreme Court decisions is the final decision, so that it means the doctrine says to stand by that which is decided. The doctrine of stare decisis reinforces the obligation of the courts to follow the same principle or the judgment established by previous decisions while ruling a case where the facts are similar or on all four legs within the earlier decision. So it is nothing but, so whenever there is a particular case and which is similar to the case which has already occurred, so and it has the bases are all similar, then and it says that the ruling case shall be the same where the facts are all similar, then it has to take the same decision as the previous decision was taken. Okay, now coming to the principles of natural justice. Natural justice, often known as jus natural, deals with certain fundamental principles of justice going beyond written law. Okay, so it also says that namo judex in casu so Literal meaning, no one should be made a judge in his own cause. And it's rule against prejudice. It's a rule against prejudice. So what happens is that you cannot become your own judge. In some cases you cannot become there are some cases, so you cannot become your own judge. That is because you obviously support yourself. So you will also have to think about the other party which has ruled, which has put a case. Then hodie altrum partem, literal meaning, hear the other party or give the other party a fair hearing. So it is not all, so there are always two parties to the cases. So you should not the court should not always give hear to only one party. It should also hear the other party, what the other party says, and take a proper decision. So once both the parties are spoken, then the proper decision has to be made in a case. The reasoned decision are the rules of natural justice. The judgment can override or alter a common law, but it cannot override or change the statute, of course. So as I told you before also, any decisions that is taken by the Supreme Court cannot be, it cannot override on any other rule, any other court. But the judgments that is taken by the lower courts than the lower court of the Supreme Court can be override by the Supreme Court, but it cannot change the statute. Enforcing the law. After a law is passed in the parliament, it has to be enforced. Somebody should monitor whether the law is being followed. Now what is enforcing? Now what is enforcing? Enforcing is nothing but compelling someone to follow the instructions in certain way. So, and once after the law is passed in the parliament, so say there is no use only when there is only the law is passed, and if you don't enforce it, then there's no purpose of that law, right? So say for example, then the parliament has proposed for a law which is called as a bill, and after the discussions and after the debates, and it is passed in the Lok Sabha, and once Lok Sabha has been passed, then it passes through the Rajya Sabha, and once the Rajya Sabha also approves it, we'll have to take the approval of President of India. Once the President of India approves it, then it will be published in the official gazette. Then once the official gazette, it should also say when it is effective from. Say it is effective from today, and from today we should enforce the law. We should implement that law in our lives. So that is enforcing. Mark this line, after the law is passed in the parliament, it has to be enforced, it has to be acted upon. Somebody should monitor whether the law is being followed. This is the job of executive. Depending on whether a law is central law or the state law, the central or the state government will be the enforcing authority. So once the law has been passed, once the bill has been passed by the Lok Sabha and Rajya Sabha, and the assent from the President of India has been taken, then the law is passed. So once the law is passed, we need to make sure that it is also enforced, followed by the people. So who is the enforcing authority? The central and the state governments will become the enforcing authority to observe that the law is being followed. For this purpose, government functions are distributed to various ministries. Some of the popular ministries are the Ministry of Finance, the Ministry of Corporate Affairs, the Ministry of Home Affairs, the Ministry of Law and Justice, and so on. So how do the central and the state government enforces the law? The central and state government cannot come and sit in every house whether this law is being enforced or not. So what happens is that the central and state government so they tried to enact, make sure that this law is been enforced through the ministries. So ministries such as Ministry of Finance, Ministry of Corporate Affairs, Ministry of Home Affairs, and Ministry of Natural Justice, and so on. There are many variety of Ministry of Agriculture, Ministry of Medicine. There are many ministries. These ministries are headed by the minister and run by officers of the Indian administrative and the other services. So these ministers, so each ministry has its own head, and these ministries are headed by Indian Administrative Services. So under these ministries there are certain offices such as IAS, and these IAS people, they these officers try to run the Indian administrative and other services, and they make sure that the laws are enforced. The Government of India exercises its executive authority through a number of government ministries or Department of States. A ministry is composed of employed officials known as civil servants and the politically accountable through a minister. Most major ministries are headed by the cabinet minister. Mark this line. A ministry is composed of employed officials known as civil servants. Who are civil servants? Your IAS people. And is politically accountable through a minister. Most major ministries are headed by the cabinet minister. So most ministries, Ministry of Finance, Ministry of Corporate Affairs, are headed by the cabinet minister, who sits in the Union Council of Ministers and is typically supported by the team of junior ministers called as Ministers of States. So Union Council ministers. So these ministries are headed by the cabinet minister. Say for example, in the Ministry of Finance, Nirmala Sitharaman at the current ministry. So she heads the finance. She heads the Ministry of Finance. And who sits in the Union Council of Ministers and typically supported by the junior ministers, who is the Minister of States. For example, Income Tax Act is implemented and enforced by the Ministry of Finance through the Central Board of Direct Taxes, coming under the Department of Revenue, and is administered by the offices of Indian Revenue Services. We will see some of the major ministers and the law which is enforced by them. Now let us also understand each and every point. Let us also understand each and every ministry. So we have Ministry of Finance. And how does it work? What are the departments in the Ministry of Finance? We have NCA, Ministry of Corporate Affairs. Then we have Ministry of Home Affairs, Graha Mantralaya. Then what are the departments in Home Affairs? Then we have Department of Official Language. Then Ministry of Law and Justice. So each and every regulatory, each and every ministry bodies we shall understand. Then the structure of Indian judicial system, High Court, Supreme Court, District Court, Metropolitan Courts. Then let's close the chapter. So let's understand each. Let's start with the Ministry of Finance. Okay. The Ministry of Finance, which is also called as Vitta Mantralaya, is a ministry within the Government of India concerned with the economy of India, serving as a treasury of India. So Ministry of Finance is a very important ministry, because where income tax department comes under picture, where central excise duties, all your taxes comes under picture. So Ministry of Finance currently is led by Nirmala Sitharaman. The Ministry of Finance is a ministry within the Government of India concerned with the economy of India, serving as a treasury of India. Please mark this line. In particular, it concerns itself with taxation, financial legislation, financial institutions, capital market center, state finances and union budget. So this ministry takes care of your financial legislation, financial institutions, capital markets. It takes care of the central and the state finances. The union budget is declared by the Finance Minister of India. As a chartered accountant, many of your day-to-day work life will be impacted by this ministry and its proclamation. So as I told you before also, as you all deal on a day-to-day basis with the finances on your income tax, there can be a change in income tax slabs. So most of your works depends upon the decisions taken by the Ministry of Finance. This ministry is so important that many ministers have preferred to hold the portfolio of finance minister also. One of the important function of the finance minister is the presentation of the union budget. Now, so every year the budget is declared in the month of Feb. So why it becomes very important in the union, when the budget is declared, your income tax slabs will be known, what budget is fixed in what area. Say it could be railways, it could be it could be in medical. So what is the budget that has been fixed, will be known in this union budget, which is declared in every year in the month of Feb. So it also impacts your day-to-day activities, it also impacts your petrol rates, it also impacts your tax rate, it also impacts the amount that has to be given for getting a product, for manufacturing. So it all depends upon the budget that is given in the every year in the month of Feb. So this, the finance minister declares the provides the presentation of the union budget. This annual event is eagerly awaited by professionals and the common man, as it provides the rates of taxes and budget allocation for ensuing year. Who presented the maximum number of union budgets as a finance minister? Shri Morari Ji Desai, during his stint as a finance minister in 1962 and 1969, has presented 10 union budgets, making it the highest. The next on the list is Shri P. Chidambaram at 9, followed by Shri Pranab Mukherjee at 8, and Shri Yashwant Sinha and Manmohan Singh have presented 8 and 6 budgets respectively. Okay, now the constitution of Ministry of Finance. So how does this Ministry of Finance work? So who are all the people in this ministry? Who acts has what in the Ministry of Finance? So let's see. Ministry of Finance is the apex controlling authority of 4 central civil services, namely the Ministry of Finance has 4 central civil services, namely the Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, and Indian Civil Account Service. So we have 4. Mark this line. We have 4 civil services under Ministry of Finance. We have Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, Indian Civil Account Service. Also, the apex controlling authority of one of the central commerce services, namely Indian Cost and Management Accounts Service. So now let's see what are the departments of the Ministry of Finance. Okay, so what are the departments in the Ministry of Finance? So we have around 6 departments. So under Ministry of Finance, Department of Economic Affairs, Department of Expenditure, Department of Revenue, Department of Financial Services, then we have Department of Investment and Public Asset Management, we have Department of Public Enterprises. So these are the subdivisions of the departments in the Ministry of Finance. So so in the central government we have variety of ministries. So in this Ministry of Finance we have subdivision, that is the departments. So we have Department of Economic Affairs, Expenditure, Department of Revenue, Department of Financial Services, Investment and Public Asset Management, we have Public Enterprises. So each department takes care of each respective respective departments takes care of each affairs, so that the composition of the Ministry of Finance is easily handled by every department. So it does not get messed up. So that was the Ministry of Finance, which is usually basically which affects the finances of the country, which also affects the finances of the people every year after the declaration of the budget. Now let us study about the Ministry of Corporate Affairs. Ministry of Corporate Affairs is usually taken care by the same Minister of Finance. So Ministry of Corporate Affairs, all your companies comes under the Ministry of Corporate Affairs. So now let us know what exactly composes it. Ministry of Corporate Affairs is an Indian ministry, Indian government ministry. Okay, so Ministry of Corporate Affairs, which is an Indian government ministry, primarily concerned with administration of Companies Act. As I told you, all your companies which has to follow the Companies Act comes under the Ministry of Corporate Affairs. So any form that you file goes to the Ministry of Corporate Affairs. So any files you do, any forms like any annual filings you do, or whether you want to incorporate a company, or whether you want to appoint a director, whether you want to remove a director, whether you want to appoint any auditor, anything, any form that you file which goes to the Ministry of Corporate Affairs, and you need the approval of the Corporate Affairs. Not in all the forms, but yeah, in certain forms you need the approval of the MCA. So in MCA also we have this ROCs, Register of Companies. So Register of Companies is different for different states. So every state has its own ROCs. So let us come to that later on. Okay, primarily concerned with administration of Companies Act 2013, Companies Act 1956. So we had Companies Act 1956 previously, which was replaced by Companies Act 2013. The LLP Act 2028 and the Insolvency and Bankruptcy Code 2016, responsible mainly for regulation of Indian enterprises in industrial and service sector. The ministry is mostly run by civil servants and civil servants of the ICAIs. These officers are elected through the civil services examination conducted by the Union Public Service Commission. The highest post, okay, mark this line. The highest post, Director General of Corporate Affairs, is fixed at the apex scale of ICLS. So the highest post, Director General of Corporate Affairs, is fixed by the apex scale of ICLS. Now, what is ICLS? ICLS is nothing but Indian Corporate Law Services. Okay. So we finished Ministry of Finance, we finished Ministry of Corporate Affairs. So Ministry of Finance is usually taken care of all the finances. Ministry of Corporate Affairs usually is for the companies, LLPs, and wherein the companies and Insolvency and Bankruptcy Code. See, the companies and the LLPs has to implement all kind of laws, and has to implement the particular act, that is the Companies Act and the LLP Act, and which is governed by all the civil servants. Okay, now let us come to the Ministry of Home Affairs, Graha Mantralaya. Ministry of Home Affairs is the ministry of the Government of India, of course. As the Interior Ministry of India, it is mainly responsible for the maintenance of internal security and domestic policy. The Ministry of Home Affairs is headed by the Union Minister of Home Affairs. So now, as I told you that every ministry has its own responsibility. Just like Ministry of Finance has the responsibility of finances for a country, the Ministry of Corporate Affairs has the responsibilities towards the companies and partnerships, LLPs, and the Ministry of Home Affairs has the responsibility of security, internal security and domestic policy. Under Ministry of Home Affairs, it has different departments. Now let us see what are the departments that comes under the Ministry of Home Affairs. Department of Border Management, which is very important in order to protect the security of the country, in order to protect against the terrorism, in order to protect the country against any kind of blast or something. So Department of Border Management within the country, the boundaries of the country which is surrounded by different countries. Department of Internal Security, Department of Jammu Kashmir and Ladakh Affairs, Department of Home, Department of Official Language, Department of States. So under Departments of Home Affairs, Ministry of Home Affairs, we have 6 departments, that is Department of Border Management, Internal Security, Department of Jammu Kashmir and Ladakh Affairs, Department of Home, Department of Official Language and Department of State. Now coming to Department of Official Language. So under Department of Official Language, we have again the three different classifications: Central Translation Bureau, Central Hindi Training Institute, Doctorate of CESS Operation. Now let us understand what is Ministry of Law and Justice. So we studied Ministry of Finance, we studied Ministry of Corporate Affairs, we studied Ministry of Home Affairs. Now we are studying Ministry of Law and Justice. Ministry of Law and Justice is in the Government of India, is a cabinet ministry, deals with management of legal affairs through the legislative department, legislative activities through the Department of Legal Affairs, administration of justice in India through the Department of Justice. The Department of Legal Affairs is concerned with advising the various ministries of the central government, while the legislative department is concerned with drafting of principal legislation out to the central government. Okay, now you need to understand two things here. The Department of Legal Affairs is concerned with advising the various ministries of central government. So the Department of Legal Affairs advises the various ministries of the central government, but legislative department is concerned with drafting of principal legislation for the central government. So there again, here we have two things. The Department of Legal Affairs advises the various ministries, your Ministry of Finance, your Ministry of Home Affairs, your Ministry Corporate Affairs. So this Department of Legal Affairs advises various ministries of the central government, while the legislative department is only concerned with drafting. Drafting is nothing but just putting all your thoughts in words. Drafting of principal legislation for central government. Draft documents are not the final documents. Final documents are the ones which is signed. Draft documents will not be signed. Okay, drafting of principal legislation for the central government. Now we have different departments in the Ministry of Law and Justice, that is Department of Legal Affairs, Legislative Department, Department of Justice. So Department of Legal Affairs gives the advices to the various other ministries of the central government. Legislative Department provides the drafting principal legislation for the central government. Then Department of Justice. Now coming to the regulatory authorities, the Securities and Exchange Board of India, that is SEBI. SEBI is a regulatory body for securities and commodity markets in India under the ownership of Ministry of Finance, the Government of India. SEBI comes under Ministry of Finance, the Government of India. It was established, please mark it, it was established on 12th April 1988 as an executive body and was given a statutory powers on 30th Jan 1992 through the SEBI Act 1992. That means the Act came into picture in 1992. It was established in 12th April 1988, but the powers was given from 1992. That is on Jan 30th 1992. So SEBI is a regulatory body, please mark it. SEBI is a regulatory body for the securities and the commodity markets. Okay, now the RBI, Reserve Bank of India, as you all know, the Reserve Bank of India is a regulatory body for the banks. Let us learn. Reserve Bank of India is India's central bank and regulatory body responsible for regulation of the Indian banking system. It is under the ownership of Ministry of Finance. Same, SEBI is also under the Ministry of Finance. RBI is also under the ownership of Ministry of Finance, Government of India. It shall be responsible for control, issue and maintaining supply of the Indian rupee. So RBI is the main bank. It is a regulatory for all the banks and it is under the Ministry of Finance. It is also the Central Bank of India. It also controls the supply of money. Supply of money as in the RBI prints the money, right? So it has the responsible and control of the money supply. It also manages the country's main payment system and works to promote its economic development. Bharatiya Reserve Bank note Murdhan is specialized division of RBI through which it prints and mints Indian currency notes. Please mark this line. Bharatiya Reserve Bank Note Murdhan is specialized division of RBI. There is a division, there is a department in RBI which is called as Bharatiya Revenue Bank Note Murdhan, which mints and prints the Indian currency in two of its currency printing presses located, please mark it, in Nasik, Western India, and Devas, Central India. Okay, so there are two places where the money gets printed and minted, that is through your Bharatiya Revenue Bank Note Murdhan, which the places are Nasik, which is in Western India, and Devas, which is in Central India. Okay, next line. RBI established the National Payments Corporation of India as one of its specialized division to regulate the payment and settlement systems in India. So RBI also takes care of, RBI also works as a main payment gateway. So it has established the National Payment Corporation of India has one of its specialized division to regulate the payments and settlement systems in India. Deposit Insurance and Credit Guarantee Corporation was established by RBI as one of its specialized division for the purpose of providing insurance of deposits and guarantee of credit facilities to all the Indian banks. So this RBI also has different divisions. So the first division that you learned was Bharatiya Reserve Bank Note Murdhan, which prints or mints the money, and the second division that you have learned is the payments gate. RBI also established the payments corporation, National Payments Corporation, which controls the payments and the settlement of the money, settlement system of India. Then the third thing that you have learned is about the insurance and the credit guarantee corporations. So this is about RBI. Now let's come under Insolvency and Bankruptcy Board of India. So this was a new concept which was brought in the year 2016. So which was Insolvency and Bankruptcy Board was a new concept which was recently bought in 2016, same like GST. So Insolvency and Bankruptcy Board of India is a regulator for overseeing insolvency proceedings and entities like insolvency professional agencies, insolvency professionals, and information utilities in India. So insolvency proceedings is nothing but when a company goes under liquidation and there becomes company becomes insolvent, then there are a lot of other procedures that comes under insolvency proceedings. So all these things is taken care by the Insolvency and Bankruptcy Board of India, which was a main board which was established in 2016. So this takes care of the insolvency proceedings and the entities, insolvency professional agencies. There are some insolvency professional agencies wherein you have to, there are certain exams that you'll have to clear to become an insolvent professional. Then this also takes care of insolvency professionals. Then just like your chartered CA is taken care by ICAI, CS is taken care by ICSI. So insolvency is also taken care by the Insolvency and Bankruptcy Board of India. Okay, it was established on 1st October 2016 and given statutory powers through the Insolvency and Bankruptcy Code, which was passed by the Lok Sabha on 5th May 2016. Then it covers individuals, companies, LLPs, partnership firms. The new code will speed up the resolution process for stressed assets in the country. So now let us understand why was this IBBI established. So before 2016, so it would become a long process for the companies to get insolvent, to the companies to pay their creditors. It was a very long process wherein the lot of money was getting stuck and lot of people were getting stuck. So that's why this IBBI, under this IBBI, the processes gets easy and the process of the insolvency gets faster. And this was established in the year 2016, and it was and this code was passed by the Lok Sabha in May 2016. Okay, it attempts to simplify the process of insolvency and bankruptcy proceedings. Please mark that line. And it handles the cases using two tribunals like NCLT and Debt Recovery Tribunal. NCLT, National Company Law Tribunal, which you will study in your Companies Act. So NCLT is a platform, NCLT is a type of a court for companies, and wherein all the cases of the companies are taken care by the NCLT. So it handles the cases using two tribunals, which is NCLT and Debt Recovery Tribunal. Okay. Now coming to structure of Indian judicial system. So we have only few more topics left in this chapter. We'll just complete of this and then we can wrap it up. Okay, structure of Indian judicial system. So as I told you, Supreme Court, the decisions taken by the Supreme Court will be the final decision. So under Supreme Court, we have variety of other courts, high courts, we have district courts. Under district court, in the state, we have variety of different courts. So now let us learn one by one. When there is a dispute between the citizen or between citizens and the government, these disputes are resolved by the judiciary. So when there is a dispute between the citizen or between the citizens, when there is a dispute between the citizen or between the citizens and the government, these disputes are resolved by the judiciary. The functions of the judiciary system of India are regulation of interpretation of acts and courts, dispute resolution, promotion of fairness among the citizens of the land. Now, what is the functions of the judiciary system? So how does it work? So there is no point when there is laws just established and kept, just signed and kept it, right? So whenever there are certain cases, so the constitution provides, constitution is the source of all the laws, as we have studied earlier. So whenever there are any cases, or whenever there are any disputes between the citizens, so these laws will give us the way to interpret the laws, acts, and give us the proper judgment or the decision for that particular case. So dispute resolution, promotion of fairness among the citizens. So it has to learn from both the parties, what are the parties saying, because in every case we have two parties, party 1 and party 2. So every party has to be heard by the law, and then the decision has to be made. The promotion of the fairness to the citizen, it has to promote proper law and order. In the hierarchy of the courts, Supreme Court is the top. Please mark it. In the hierarchy of the courts, Supreme Court comes first, and then comes the high courts, and then comes the district courts. So Supreme Court is the highest court. It is followed by the high courts and the district court. Decisions of the high courts are binding the respective state, but are only pervasive in other state. Decisions of the Supreme Court are binding by all the high courts under the Article 141 of the Indian Constitution. Now, okay. In the hierarchy of the courts, the Supreme Court is the top, followed by the high courts, district courts. Decisions of the high courts are binding. Decisions of the high court are binding in respective state, but are only persuasive. What is persuasive now? It is nothing but having the power to intend. So high court's decisions are, in every state has its own high court. So high court's decisions are covering, are applicable only to that particular states and not to any other states. But the decisions taken by the Supreme Court are binding all the high courts. So any decisions that is taken by the Supreme Court, which is the highest court of the country, is binding all the high courts. But any decisions taken by the high courts is binding only that particular state and not all other states. Okay, the decisions of the Supreme Court are binding all high courts under Article 141 of the Indian Constitution. In fact, the Supreme Court decision is the final word of the matter. Okay, now under Supreme Court, let us see. Supreme Court is the apex body of the judiciary. It was established on 26 January 1950. The Chief Justice of India is the highest authority appointed under the Article 126. The principal bench of the Supreme Court consists of 7 members. Please mark this one. This is a constitution of the Supreme Court. So how many people are there? Who is the Chief Justice? So all of these are the constitution of the Supreme Court. Please mark it. The Chief Justice of India is the highest authority appointed under Article 126. The principal bench of the Supreme Court consists of 7 members. So the constitution of who all constitute a Supreme Court? First is a Chief Justice, who is the highest authority appointed under Article 126, and followed by 7 members. Including the Chief Justice. That means including Chief Justice and the other 6 members, right? So 6 members, 1 Chief Justice, total 7 members. Chief Justice of India. Presently the number has increased to 34, including the Chief Justice of India, including the Chief Justice, to raise the number of cases and workload. So before it was only 6 members and 7 members including the Chief Justice, but now the number has increased to 34, including the Chief Justice. So including Chief Justice of India, today the number is 34, as the cases and the workload has increased. An individual can seek relief in the Supreme Court by filing a writ petition under Article 32. So if a person or if an individual wants any decisions that has to be taken care by the Supreme Court, wants to hear the decision by the Supreme Court, then he can go, an individual can seek relief only by filing a writ petition under Article 32. Now let's see the High Court. The highest court of appeal in each state and union territory is the High Court. So as I told you, the highest court in the country is the Supreme Court, but the highest court in their respective states is the High Court and the union territory. Article 214 of the Indian Constitution states that there must be a high courts in each state. So every state has its own high court. The high court has appellate, original jurisdiction, supervisory jurisdiction. However, Article 227 of the Indian Constitution limits a high court supervisory power. As I told you before also, the High Court does not have all the power. High Court does not have the power to take the decisions on every matter. When it comes to the national security of India, or when it comes to any matters concerning India, the decisions will be taken by the Supreme Court and not the High Courts. Okay, has any decision which has been taken care by the Supreme Court will cover all the High Courts. Okay, High Court supervisory jurisdiction. However, Article 227 of the Indian Constitution limits High Court supervisory power. In India, there are 25 High Courts. Please mark it. In India, there are 25 High Courts, 1 for each state and union territory, and 1 for each state and union territory. 6 states share a single High Court. So, now, in particular, there must be High Court in every state, but there are currently 25 High Courts, and 6 states share single High Court. So there are 6 states which share the single High Court. An individual can seek remedies against violation of fundamental rights in High Courts by filing a writ under Article 226. So if you want to file any relief, and if you want to obtain any decisions that has to be taken by the Supreme Court, you can file a writ petition under Article 26. But if you want to if you want any relief from the High Courts, then you will have to file a writ under the Article 226. Which is the oldest High Court in India? The oldest High Court in India is the Calcutta High Court, established on 2nd July 1862. Okay, now we have learnt about the Supreme Courts, we have learnt about the High Courts. Now let us learn about the District Courts. Below the High Courts are the District Courts. The courts of the district judge deal with the civil law matters, contractual disputes and claims for damages, etc. The courts of sessions deals with the criminal matters. Okay. Under High Courts, below the High Courts are the District Courts. So in the District Courts, in the District Courts deals with the civil law. So the court of district judge, there are 2 things here again. So the one which deals with the civil law, the one which deals with the criminal law. The court that deals with the civil law is the court of district. The court that deals with the criminal law is the court of sessions. Mark that line. The court of district judge deal with the civil matters, contractual disputes and claims or damages. The court sessions deals with the criminal matters. Under pecuniary jurisdiction, a civil judge can try suits valuing not more than rupees 200 crore. Please mark this line. Now, what is under pecuniary jurisdiction? A civil judge. Now, a civil judge in a district court, what happens is that a civil judge can deal with the cases only the value not more than 2 crore. So, if the value is more than 2 crore, then the civil judge cannot handle the matter. It has to move to the High Court, the next court after the district court. Jurisdiction means the power to control. What is jurisdiction? Jurisdiction means the power to control. Courts get territorial jurisdiction based on the areas covered by them. So, jurisdiction can be from the area. So, every area will have, say certain, say in your area there can be a territorial jurisdiction. There can be a district court, and that district court will have a areas which will cover, just like your police stations. Some certain every area has its own police stations. So which area comes under which police station will be a matter. So that is the jurisdiction, the power to control the area. Court gets territorial jurisdiction based on the areas covered by them. Cases are decided based on the local limits within which the parties reside or the property under the dispute is situated. Say for example, if you are staying in one area and your property is in another area and there is a dispute in the other area, so you will have to go to the area where your property is located, which has a dispute. You cannot have a case in the area which you are located. Okay, so every area has its own every area comes under particular jurisdiction. So you will have to go to that jurisdiction courts and apply for a case. Okay, now metropolitan courts are established in metropolitan cities in consultation with High Court, where the population is 10 lakhs or more. So every city does not have a metropolitan courts, but these metropolitan courts are established in metropolitan cities with the consultation of High Court, and the population should be 10 lakh or more. Chief Metropolitan Magistrate has the power, has Chief Judicial Magistrate, and Metropolitan Magistrate has the power of, please mark this line. Chief Metropolitan Magistrate has the powers of Chief Judicial Magistrate, and Metropolitan Magistrate powers as the court of the magistrate of the first class. Okay, so these are the courts. First is your Supreme Court, High Court, District Court, and Metropolitan Courts. So every city does not have a metropolitan courts. Only metropolitan courts are established in the metropolitan cities with the consultation of High Court. Okay, so you have certain questions here that you can do it, and you also have answers behind it. So yeah, let's wrap up this session and we'll see in the next class. Thank you. Bye.